be a well-planned township consisting of a well laid out houses, road, market, school, temples, and drainage system. But however, with the advent of the British in the 16th century, everything changed and it got anglicized from Bengaluru to Bangalore. Now, in 1898, there was an epidemic that took place in Bengaluru. So, dear friends, now we are in the midst of a pandemic, but Bengaluru has faced this in 1898 itself, and it took about 3,500 lives. And subsequently, a health minister was appointed. All this during the British regime. And in the 1900, um, Lord Curzon inaugurated the Victoria Hospital. In 1903, a motor vehicle started plying in Bengaluru for the first time. And in 1906, Bengaluru was the first city to get electricity from the Shivanasamudram power plant. Indian Institute of Science has been established in 1909. And in 1927 and 34, Bengaluru has played a pivotal role in the freedom struggle when Mahatma Gandhi had come to Bengaluru, and he had also given a speech inspiring the people to come together for the freedom struggle. It is also relevant to mention that Bengaluru got its name Garden City in 1927 under the King Wadayar IV. And for the first time in 1940, the plane service from Bangalore to Bombay took place. So this is pre-independence. So these are some of the reasons how there has been a slow but sure transition that has taken place. The positive vibes that I would say. Now the post-independence period. In 1961, MICO was set up. There was also HAL and other industries like HMT, that is Hindustan Machine Tools, Indian Telephone Industries, and NGEF, BEL, all this was set up. So what happened is this gave an opportunity for a lot of people to migrate from other states, and they came in from the neighboring states, especially of Kerala, Tamil Nadu, Andhra Pradesh, and some of them from the north also started coming and settling in Bengaluru. So this is how the population slowly became a mixed population in Bengaluru. Now what happened is, I would also say that Bengaluru is also known as the defense hub, because you had the defense establishments such as DRDO, NAL, then Raman Research Institute, Center for Artificial Intelligence Robotics, LRDE, all this were set up at the relevant point in time. In fact, as late as yesterday, I was watching the news, and it's a good news that the DRDO has been instrumental in setting up an anti-missile for our warplanes for our defense in Indian Air Force. And definitely the defense hub has played an extremely important role. Then comes the late 70s, early 80s. We are aware of Infosys, which was set up by Sri Narayana Murthy. There is also one more company known as Mastech, which was set up by 4 IIM graduates as early as in 1979-80. IIM Ahmedabad pass-out graduates. And that was also an IT-driven platform. In 1985, Texas Instrument came to be set up. But the turning point, as I told you, was during 1990-91 with the post-liberalization period. This under the leadership of our former late Prime Minister, Shri P.V. Narasimha Rao. This gave a very good opportunity for FDI, that is foreign direct investment, to come into the city, to the country, and foreign and a lot of companies were set up in the city, especially software companies. And rightly so, Bengaluru came to be known as the Garden City. The Silicon Valley of the South. At this relevant point in time only, this is the main point when builders started realizing that Bengaluru is the place that they should start all the development work and all the things to be done over here. This was the time when they realized that this is a hot spot, and a lot of changes started taking place. So the changes took place to such a humongous stage that lot of huge pieces of land, huge bungalows, old houses, and a lot of agricultural land were converted to residential purpose, and a lot of activities took place. So you could see a lot of apartments coming up in different parts of Bengaluru, as well as the other aspect that came up was residential layouts. So this was the turning point. And then subsequently, towards the turn of the century, a lot of developments took place. Now the question that comes up is, how come Bengaluru? So our very own Jnanapith awardee Shri U.R. Anantamurthy, he gave a proposal to the state government in 2005 to change the name from Bangalore to Bengaluru. And subsequently, it was considered in 2014, 1st May 2014, and subsequently on 1st November 2014, Bangalore came to be known as Bengaluru. So this is the transformation that Bangalore has taken place. Here, I would like to mention one more point. That is the true architect of Bengaluru, Kingal Hanumantaya's mother had given him one inspiring word. The inspiring word was this: build lakes, plant trees. I call it Kere Mattu Kadu in Kannada. Three important aspects I wonder would be the main reason for this. The first important reason is because Bengaluru has got a very good climatic condition. And lot of we need to show a lot of reverence to the Kannadigas over here, who have been very benevolent enough to accept everybody and anybody who came to Bengaluru and settled down in Bengaluru. Third aspect is the aspects that I told you. One is the industrialization, the defense hub, and then the IT sector. All this propelled and gave the momentum for this vast change in Bengaluru. So, dear friends, with this, I would like to complete the first segment. I thought I will just give you an introduction so that we get to know what Bengaluru was and how it has changed in leaps and bounds. So now I shall go to the second segment. Yeah, the second segment is the different kinds of properties. So the different kinds of properties, as you see on the screen, are it is segregated into different aspects. Now I've done this segregation for so that it is beneficial for everybody to get an idea about the whole thing. So the first is site. So when you talk about site, Bengaluru is a place where you have sites of various dimensions. So there is no specific thing as such. You get sites as in the dimension as small as 20 by 30, 30 by 40, 40 by 60, or even 35 by 30. So now when we look at this aspect, the sites are segregated in various parts of the city. For example, when you look at this small dimension sites, you find them in places such as Alsor or Lingarajapuram, or maybe even in Electronic City and all those places. The big sites that we're talking about, 50 by 80 and all that, we find these sites in Indranagar, Basveshwar Nagar, Jayanagar, and all those places where the sites are of bigger dimensions. Now, actually speaking, when you talk about sites also, the sites can again be segregated into two aspects. That is revenue site and DC converter. Revenue sites are those sites which have not been converted from agriculture to residential purpose. The law provides that any site for that matter needs to be converted from agriculture to residential purpose. There is a provision under the Karnataka Land Reforms Act, and it is a conversion of the land as per Section 95, Clause 2, Clause 4, and Clause 7 of the said Act, subject to certain terms and conditions. The Act the particular section says that the reason for which the site is intended to be converted should be used for the same purpose only. It cannot be used for any other purpose. That is a first that is a prerequisite, and it is subject to the clause in clause 2, 4, and 7 of the said Act. Now, when a site which is, if you observe, sometime during the late 90s, there were a lot of sites that cropped up around KR-Puram and various other areas. Most of the sites were revenue sites. Since the city had grown in leaps and bounds, the population, the moving population, or the transition of the population from even North Karnataka and everything started coming towards Bengaluru. A lot of people started settling down in various parts of Bengaluru, and the greenbelt area started extending beyond the certain parameters. And that is where most of the sites were revenue sites, and people started constructing houses, and then they started regularizing after doing the construction and all that, probably by paying the requisite charges and all that. The other one is the conversion with as per the DC, that is the Deputy Commissioner. This again is as per the Karnataka Land Reforms Act. The conversion takes place, and the special Deputy Commissioner, or the Deputy Commissioner or the Assistant Commissioner has got the powers to for getting the for giving orders to convert the land from agriculture to residential purpose. So once the land is converted, then accordingly they can do the residential construction. Nevertheless, with regard to DC converted sites, what we get to see is DC converted sites are basically sites that are converted, but again certain points may not be, I mean certain aspects would not have been considered. So what happens is, again there would be a possibility that the lands needs to be it may not be in a authorized layout. Now the layouts again has to be considered, whether it's an authorized layout or an unauthorized layout. If you look at many layouts, some of them are not authorized layouts. It would have been converted, DC converted lands. So again, that aspect is considered when it comes to sites. So when you purchase a property, you need to ascertain all these aspects. Normally what happens is everybody are eager enough to purchase properties. The moment we see an advertisement or something, everybody wonders, all right, let me get into this and purchase this property. But one thing I would always caution is, always ensure that the papers are perfect, because the logic is very simple. Don't buy in a haste and repent in leisure. Rather take your own time and buy a property and settle down peacefully in the property. The next is plots. So what is the difference between a plot and a site? Both are piece of land only. The only thing with regard to a plot is it is in a gated community, preferably. Whereas in a site, it might not be necessarily in a gated community. In a plot, in case of a plot, it is in a gated community. And one more thing with regard to site is, normally you have a single owner. And the basic documents that you need to look at is mother deed, sale deed, khata, encumbrance, tax paid receipts. When it comes to a plot, there are two ways to look at it. The builder might either go in for a joint development with the owner, or it may be a owner come developer, which means the builder would have purchased the property, the entire piece of land, and he would have done the construction on his own. He would have developed the residential layout. So again, there what you need to look at is, there are certain documents that one needs to glean. So this is very important. There is something known as, in Kannada, it is known as Prarambika Pramana Patra, which means work commencement certificate. There should be a sanction letter. Then they have to get the clearance from the various authorities. Then the builder should be able to provide overhead electric cables, that is electricity facilities. Then he has to provide water facilities. There should be a water facility provided. STP is important. Sewage treatment plant is important. Arterial roads, and a certain area should be kept separately for greenery, that is landscaping and all that. So these play an extremely important role. Whether it is whether he gets into a joint development or whether he does it on a individual basis. Now, if it is a joint development, then the owner will have to give a GPA, that is a general power of attorney, to the developer. He should also enter into a joint development agreement. And if you observe, both these documents will have a same date, because first the power is given, that is the owner gives the right to the developer. And if you see the JDA, that also will be on the same date. And if you observe very closely, only the timing will be different. So we, as lawyers, we have to glean all this. We see the timing, because it should not be predated. You don't give a joint development and then you don't give a GPA. First you enter into a GPA, then you enter into a joint development. After that is done, there is a sharing agreement or an allocation agreement entered into between the owner and the developer. So it will be like 40% is to 60%. That is 40% rights given to the owner, 60% to the developer. In all these projects, if you observe, normally a greater chunk of the percentage goes to the developer, because he is putting in the financial resources. So this is how it actually happens. So again, they have to form they have to develop the project and all that. Only after the complete development of the project, they will be in a position to actually they're supposed to sell the project, or in the meantime they also enter into an agreement to sell with the purchaser. Now I will also explain with regard to the RERA in the next segment, wherein I will touch certain points with regard to what I'm speaking now also. So this is what is got to do with plot. Next is apartment. Now when we talk about apartment, the first thing that comes in our mind is buildings. We are talking about huge apartments. Now again, apartments can be segregated into two types. I would like to segregate it into two types. One is apartment which consists of ground plus 3 floors. Another one is apartment which consists of ground and maybe above four floors. That goes to even 10 floors or even 15 floors. Now you have builders such as Godrej or Pashmina Waterfront in KR Puram or Salapuria Greenage. Theirs is all tower constructions. So basically what happens first is with regard to ground plus 3 floors. Now when it comes to ground plus 3 floors, the basic requirement is again you have to ascertain where the property is. Now with regard to all these properties in this section, the first is you need to ascertain where the property is situated, and then you need to ascertain who's the authority. So it's not necessary that only BDA will have to give clearance for all the other for apartments with ground plus 4 floors and above. Even BBMP is also having the right and the powers to do so. However, it depends which area it is situated. Now, when we talk about which area to situate, it means it is the zonal area. Now, there is a zonal area, which means when you look at the map in the concerned authorities, the BDA or the BBMP, you have the different colorings in that. Now, yellow color stands for residential, red color stands for transport, that is highway transport, like the roads on the way to the highway, that is to the international airport. All those arterial roads and everything, that is in the red zone. And when it is green zone, it is for agricultural purpose, and and pink zone is for industrial purpose. And in pink also you have light pink, dark pink, and all that. But again, it depends. That is basically industrial purpose. So this is the segregation. So when you look at a particular project, you should know where. If you are going to buy a property, you should know where it is. Now, suppose you are buying a property which is beyond Devanahalli, you will not find the details in BDA. It comes under BIAPA, that is Bangalore International Airport Area Planning Authority. So I shall come to that also next in the next segment. So coming back to this apartment, in this apartment also it is segregated into two parts. As I told you, one is ground plus 3 floors, other one is ground and above 4 floors. When it is above 4 floors, there are a lot of strictures that needs to be followed. For example, clearance from the Airport Authority of India, the Defense, Fire Department, the Commissioner of Police, all these authorities have to give a clearance. And there is something known as a setback that has to be kept and all that. And when it comes to apartment also, there is a very important aspect to be considered. There is, as I told you, like in the residential sites, same thing with the apartments also. There is a very important aspect to be considered. That is, it is got to do with the work commencement certificate. So when you're looking at an apartment kind of a setup, there are things that you need to look at. It's a work commencement. You need to look at work commencement certificate. Then you will have a sanction plan, sanction letter, and then you have, for example, if you may split this into 3 aspects again, I will put it as A, B, and C. A is the owner, B is the developer, and C is the purchaser. Now from the A, so when it's a joint development agreement, what happens is you need to the documents need to be looked from basically 2 vantage points. That is A and B. A is the owner. Now who is the owner? How did he get the property? Whether it was by way of occupancy rights, whether it was by way of in arms abolition, or whether he got it by way of a gift, will, sale, settlement deed of exchange, or whether it was a property through auction. So all this has to be considered, and or whether it is by way of inheritance, that is will. All this will be considered. Then next is we call it as Vamsha Ruksha, which is a family tree. we see his family tree to know how many children he's got, his wife and children and all that. Because and the next is whether the children, any child is a minor or a major. Suppose the project is nearing completion, and if a child is say about 16 years and the project is scheduled for completion in 2 years, by the time the project gets completed, the minor can become a major, and there is a possibility that he can also file a complaint saying that I had a right in the property, but my father sold the property, or he entered into a JD agreement. So, as I told you, then again it has to be considered on these aspects. We look at from this angle also, this point of view, from the owner's perspective. So, we have to ascertain what are his locus standi or his rights over the property, and whether his children are minors or majors, that aspect is considered. Then there are some documents such as, the khata, the conversion of the land. The land is has to be converted before he enters into a JD agreement. Normally, the owners will have to get the land converted, and they also have to pay whatever is the requisite charges to be paid. All that has to be paid. Then there are documents such as IL and LR, that is Index of Land and Land Records. And there are documents such as inheritance, RTC, that is a record of tenancy and crops, record of rights, then MR, that is mutation register. Then we look at the encumbrance certificates, tax paid receipts. All these documents come from the owner's perspective. We'll have to look at all these documents. Then there is something known as Hissa, Tippani, Nakalu, Akarband. These are from the owner's perspective. Now coming to the builder's perspective, that is B. Now, from the builder's perspective, a very important aspect to be considered is the builder, whether he's a private limited company, a partnership firm, or a proprietorship concern. And if it's a partnership firm, whether it is a partnership firm under the Indian Partnership Act 1932, or whether it is a limited liability partnership. Now, again, under partnership, if he's a partner, we have to ascertain whether it is a partnership at will, as per Section 7 of the said Act. If it's a partnership at will, then you have to be very watchful. The reason is because two persons assume come in as partners, and they form a company, and they form a partnership firm, and they start the development. Now, once the project is over, it is a partnership at will. So once the project is over, one of them can just walk out saying that I am complete with I am walking out, I am done with it. And suppose if the project is not complete, then who will you go and sue if that person is having a major stake? So all these aspects have to be considered before even purchasing a property. So from a legal perspective, from a lawyer's perspective, these are the things that goes behind documentation. We have to go through all these documents in order to ascertain a sense of clarity. So that is with regard to apartments. And once the apartment is completed, then occupancy certificate has to be given. Now again, what happens is there is a provision where the builder has got an option to, I mean, there could be some deviation. It cannot be picture perfect. He will get it from the architect's boardroom drawing and all that. There could be some changes here and there, but the change should not be too humongous. If it is too large a change, and if there's a lot of deviation, then he will have to pay the fine or penalty or whatever, as the case may be. And only if he's in tandem with what is in the sanction plan, does he get the eligibility to get the occupancy certificate. After that, an apartment association has to be formed. That is in accordance with the Karnataka Apartment Ownership Act 1972, Rules 1975. There is something known as a Form A and Form B, and there is something known as a deed of declaration. Now, when we talk about this apartment association, Maharashtra is very popular for this. You have the Maharashtra Apartment Ownership Act. Now, we are just following their footsteps, because as I told you, Bangalore is just about 30 years old with regard to this whole concept. And with regard to the apartment ownership, when we talk about this, what I would always suggest, and I always prefer when I tell my clients, is one thing is very clear. Ensure that once you're done with it, coordinate with the builder, form an association, and get all the original documents and put it in an escrow account. You have an escrow account that is created, an account that is created, put all the original documents from the developer and have it in the account, and that will become the mother deed for it. So coming back to the next one is villas. Now, when we talk about villas, Villas are everything is got to be on the same. It is as similar as apartments only. In the sense, these are all row houses. So normally, what happens is there are villa plots and villas. So what happens is builders, what they do, like as I told you in the second segment, that is plot. As I told you in the second point, the first is site, second is plot. Like in the plots only, this also will be in a residential. It will be in a gated community, but they will have same kind of construction. For example, if you look at places in Chandigarh, Chandigarh has got one thing where all sectors, everything has got same kind of construction, the similar construction. And even in villas, you have the same, everything will be same kind of construction, and there are certain this one to be followed. And you cannot have construction of your own. For example, I will give an example. There was a client of mine who approached me saying that he was purchasing a plot. He said it's a villa plot and all that. Then when I had a look at the documents, I felt there was something which was not very clear. Then I asked him some more details, and that's when I got to know that there is a very important aspect. The owner spoke to me and said, "No, sir, it is actually villa. It's for villa only, but we are not doing villa. He can go in for multiple constructions also." And when I asked him some more questions, then I came to know that there was actually some problem in that. Which the owner who had entered into a JD agreement with the developer had not mentioned it. So we will need to ask them. The question was very simple. When a particular area is completely allocated only for villa, everything has to be villa. When there are 6 sites, everything in villa, one site cannot become. You cannot just sell it for some other purpose because you have a specific sanction plan for that. When it is meant for villa, it is meant for villa purpose only. You cannot go for multiple constructions beyond a point. So it has to be, everything has to be in tandem. So the next one is, as I told you, is a villa. That is a villa. Villament. Villament is nothing but a villa or villament. Now there's a new concept that is coming in. They say that it's like a villa and apartment together and all that. As I've already explained the other two things to you. And the next is we can say is agriculture land. See, basically, agricultural land in Bengaluru, if you observe, Bengaluru was known for its greenbelt area. It is also known as Gomala. Gomala is basically grazing lands. So most of the areas, if you look at Nakundi village on the way to Marthali bridge to the left, if you go that side, that area was all, it was actually considered literally as an outskirt, and it was all greenbelt area. Marathali, everything was a greenbelt area. KR Marathali, that complete belt, Sarjapura. Today, the development is grown humongously. So when you say a greenbelt area grazing, it is basically for grazing and growing of standing crops and all that. Now again, what happens is there is this there is this thing known as the Inams Abolition Act, or the granted lands, or PTCL, that is prohibition of transfer of certain lands. Now when I talk about prohibition of transfer of certain lands, this is very important. We need to look at this aspect. Now, what happened is the government used to consider the lower sector of people and low income group sector of people, and they came up with this provision as providing land at a very nominal rate for the SC/ST, scheduled caste and scheduled tribe. So now the logic was that comes under the PTCL, that is the prohibition of transfer of certain lands, 1988. So the provision is very clear. It says that once a land is given to a person who's from an SC/ST background, he cannot sell the land to another SC/ST person itself, leave alone selling it to a third person. So if anybody buys a land from a person which is a granted land which is given to him under the provisions of the PTCL Act, then let me tell you, that person is doomed. There is no way he can go to the court and claim this one and get back the land. Now the logic is this: there is one simple concept in law. It says that ignorantia non law excusat. Ignorantia law non qui excusat, which means ignorance of law is not an excuse. Reasonable efforts have to be made. And again, in contract, there is one more aspect. This, when I say contract, it is applicable to all this in this second segment. It is applicable to all this. When I say ignorantia law, when I say that in contract, because it is a contract between two persons, A entering into contract with B, whether it is a single site or whether it is a plot with a developer or whether it is an apartment. The law says that doctrine of caveat emptor, which means let the buyer beware. When a person is purchasing a property, whether it is a piece of land, a plot, or an apartment, he should have done a reasonable due diligence. And despite doing the due diligence, if something goes wrong, he can then take the defense that he has done all that he could within his capacity. But without doing any due diligence, just going and purchasing a property, then tomorrow if he comes back and says he goes to the court and feigns ignorance, the courts come down very heavily, because the court says do your homework, then something doesn't happen, that's a different thing. So the next one is industrial land. Industrial land, as you say, yeah, industrial land is basically the KIADB, that is Karnataka Industrial Area Development Board. That's what we say. So industrial lands are lands which are basically, if you observe, these are, as I had mentioned it, the zoning section and all that, the pink zones. So the industrial lands are basically lands that are situated, if you observe, it's very simple. You can know industrial lands will always have a separate industrial layout or an industrial area. For example, you have Pina, you have Jigni. These are all industrial estate. This is specifically only for industrial purpose, and the law is very clear. Once a land is provided for an industrial purpose, it has to be used for that purpose only. And the next aspect that needs to be considered is they have to it is meant for setting up a plant or a project or something like that. And normally why it is on the outskirts is because there could be a chemical industry, there could be an industry which deals with the medical aspects and all that. So the affluence and all that is let out from the industry, it has to be in around that area only. It should not be near the it should not go near the other areas, that is it should not be near the city limits. So if you observe, you will never find any housing community close by, but you might find it at a distance. This distance would be basically with regard to housing for the members, that is the factory members, the workers who are working in the factory. So they have a housing colony somewhere close by. Otherwise, the government does not provide any housing, sites around that area. It's only meant for industrial purpose. And heavy fine is imposed if they don't use it judiciously. And one more thing I wanted to tell you, when it came to agriculture land, now there is a provision where there was a provision as per section 79AB of the Karnataka Land Reforms Act with regard to agriculture land. So who could buy a land and all that. Now the provision is clear that even anybody is eligible to buy agriculture land. There is no strict strictures as such. Now the provision is they have sort of lifted the strict strictures, and now there is a provision where you can even anybody is eligible, but it has to be used for a particular purpose. That's very important. The next is we talk about is farmlands. Farmland is basically that land which is used for farming purpose. Now normally what happens is people buy lands. Say assume for example maybe about 1 acre of land. Now 1 acre of land is purchased for farming purpose. They cannot just convert that into a multiple dwelling or a tenement and then put it on rent and all that. It is something like an outhouse, we say, which means predominantly it will be for all these crops, horticulture, that is flower or standing crops such as vegetables or fruits or something, and you can have a small outhouse over there, and it is you are eligible to have a farmhouse, and you can use it for it is something like closer to nature and all that. If you look at lot of properties, I mean lot of vegetables that comes into the city, it is also coming from all those farmhouses which is situated on the outskirts. For example, places such as Whitefield and all other areas. So now coming to the next aspect, that is the commercial properties. So basically, if you observe in Bengaluru, there are properties that is also now coming as commercial properties. Now, apart from residential, what you observe is there is something known as a mixed construction. So commercial properties basically properties, if you observe, this is for commercial purpose only. So if you look at mixed constructions, for example, Prestige Shantiniketan, there you have both commercial as well as residential. Today now the trend is changed. Builders, what they do is they have a commercial property at the start. when you enter into a project, you usually have commercial property at the starting, and as you go inside the project, when you go to the other side, it is you have it as A wing and B wing. A wing is going to be the commercial property, B wing would be the residential property. So that is known as mixed construction. So when you look at sanction plans, when you look at the sanction plan, it will be very clearly mentioned mixed construction. When you see it's mixed construction, then you can be sure that this has got both commercial as well as residential. So that's how we get to know, identify both the things. Again, in the commercial property also, depending on the area, how many floors can be constructed will be, everything will be reflected in the sanction plan. So the sanction plan plays an extremely important role. So, and the last is KHB, Karnataka Housing Board. Now, as you know, Bengaluru, as I told you, has grown in leaps and bounds. Karnataka Housing Board is actually it's a successor to the Mysore Housing Board Act of 1956. Karnataka Housing Board Act came in 1962. The main purpose of this was to provide affordable houses for the residents of Bengaluru. So you see a lot of housing board and colonies and all that, KHB colonies and all that. But today, with the development of all these, apartments and all that, high-rise buildings and high-profile builders and all that, KHB has stopped to a certain extent. It is more so with regard to all the other high-rise buildings and all that. And I'm given to understand that even in Mysore, they are coming up with a housing colony, Karnataka Housing Board. About 2,500 houses are proposed to be constructed. But again, they have to get a clearance from the Ministry of Environment and Forest. So the third segment is with regard to the various authorities. Okay, the third segment is with regard to the various authorities. So as you see, the various authorities are CITB, that is City Improvement Trust Board, and all these authorities. Basically, City Improvement Trust Board was in the year 1945. And subsequently, it was the BCC, that is the Bangalore City Corporation, in 1949. So this was Bangalore City Corporation. Then it was a merger of corporation and Bangalore. It was a merger of the corporation and the cantonment. So if you look at documents way back in 1960s, 60s and 70s, some of the documents you find it as military. This one there is a reference which says as a military station Shivajinagar. If you see documents relating to 1964-65 sale deeds. And subsequently, 1966, you had the KIADB, that is the Karnataka Industrial Area Development Board, that was set up, as I had already spoken in the earlier segment. So again, it is meant only for these purposes, that is for industrial purpose. The next aspect, the next one is we have the BDA Act 1976. So the BDA Act was set up on 20th of December 1976, and the main purpose of the act is basically to provide the basic facilities and amenities for the public. Now, when you look at this, amenities means road, street, lighting, then you have public works and drainage system. This has got to do with the amenities. And there is something known as civic amenities. If you observe, there is a civic amenities site. Civic amenities site, why I would like to mention at this point is because basically, if you look at all this, civic amenity sites are sites which is meant for benefit of the public. So nobody can actually own a civic amenity site. For example, you have the milk booth, market, dispensary, school, hospital, pathological laboratory, playground, post office. All this comes under the civic amenities. And as I had mentioned in the earlier segment also with regard to conversion of the land is converted from agriculture to residential purpose. So once the conversion takes place, there's something known as conversion charges that has to be paid. So that has to be paid as per this section, section 20 of the BDA Act. They have to pay the conversion charges. And conversion charges or the betterment charges have to be paid. And then it gets regularized. And subsequently, the land is used for what it is meant to be, for what the change of land use has been sought for. If it is for residential purpose, residential. If it's for industrial purpose, industrial purpose. It depends on that. And then the next that we have is with regard to the other aspect, that is you have the BMRDA that was set up in 1986. As I had mentioned in the earlier segment also, the ODP, that is the Outer Development Plan. So where the property is situated depends on that. So BMRDA actually refers to the ODP, that is the Outer Development Plan. Those properties which are situated on the outskirts, especially Electronic City, then far beyond Basveshwar Nagar and all those areas, it comes as the ODP. That is the Outer Development Plan. And then you have BIAPA, that is Bangalore International Airport Area Planning Authority. Now, this was again 1996, as you're all aware. We had this airport in Devanahalli. The lands around that area was being acquired for the airport. In 2008, the airport has been set up, but BIAPA basically comes beyond Devanahalli and that area. So you have the Directorate of Town and Country Planning. So any lands that you intend that is intended to be purchased comes under the BIAPA, and there that is the authority where you have to get the whole thing to be done basically. So the next aspect is we are looking at is that is BBMP. Now, as you know, BBMP, see, basically there was 7 CMCs and 1 TMC. CMC is City Municipal Council. TMC is Town Municipal Council. There were 7 CMCs and 1 TMC. And subsequently in 2007, everything has been merged and it has come under the BBMP. So now if you look at Bengaluru, it is in the different divisions, and this BBMP actually plays an extremely important role, like for any kind of construction that takes place around the city limits. Depending on where the area is, they have to approach the concerned BBMP and go in for the clearance. I would say that BDA is something like an apex body, not in the complete sense, but the BDA has been established basically for the purpose of for the development of the city at large. Their main purpose is for all the to provide all the amenities and all that. In fact, CITB, which I told you earlier, which was established in 1945, that has actually come that has now become BDA. And BCC, which is Bangalore City Corporation and all that, that is now completely changed. Now everything has come under the BBMP. So that is Brihat Bengaluru, or you also call it as Greater Bangalore. As Bangalore has grown in leaps and bounds, the government has also made a lot of efforts to ensure that if it's possible, I mean to cater to the needs of the people and the growing population as well as development, they have sort of got it to that level. So these are the basic authorities. And the last one more thing is with regard to RERA. Now, as we all say, RERA is a very important one, and this is a subject unto itself actually. RERA is a subject unto itself. However, I would just give a small, we'll just have a small sneak peek into this. Maybe a lot of more questions and all that. I'm more than eager to answer through the mail also, give some more inputs. However, I will just cover up this aspect of RERA. So RERA has it is the Real Estate Regulation Authorities Act 2000, Authorities Development Act 2000, Development Authorities Act 2016. It has come into effect on 11th of July 2017. So this is applicable for all the under construction projects and new construction projects. And with regard to sanction plan and all that, this particular act is a level playing field actually. It actually ensures that there is a win-win situation for both the purchaser as well as the developer. Now, it is applicable to the developer, purchaser, as well as even real estate agents. So if we were to observe one thing very closely, developer and real estate agents were actually, they had a tacit understanding with each other. So whenever a person intended to purchase a property, RERA basically, it's a level playing field, as I told you. The main important aspect of RERA is it actually ensures that formally what used to happen is builders and real estate agents used to get into a tacit understanding, and invariably any person who wanted to purchase a property, he used to approach real estate agent, and he will have an understanding with the developer, and they will, most of the lands would be, most of the flats would be sold. Even when you were to look from the in the social media or any other aspect for that matter, advertisements that comes on various medias, so various this one such as 99 acre or whatever. Now with the advent of the RERA Act, what happens is a builder has to register himself with the RERA authorities. And before registering with the RERA authority, he will not be able to advertise, promote, market, or sell his project. First, he has to register, then there'll be a RERA number given to him. And if he intends to give any publicity or advertisement in the print or the electronic media or even hoardings, the RERA number has to be reflected. This is a prerequisite. And the next aspect is with regard to the carpet area. Now, in RERA, what has happened is now there is something known as a carpet area. Carpet area means the inner wall to inner wall. The plinth area, we call it as. And this reminds me of the Karnataka Rent Control Act 1999, wherein this reference of carpet area was mentioned over there also. So now coming back to the carpet area, what is the difference between a carpet area and a super built-up area is, super built-up area includes everything along with the carpet area. Carpet area is within the building. Super built-up area includes all the corridors, the common area, and everything is included as a super built-up area. But I should also caution you that the super built-up area is still being considered despite the carpet area, because even in places such as Punjab and all that, you still have registration on the basis of the SBA only as of now. This amendment is still happening. It is still getting the heat is on, and as it is a central act, it is from the center, but it is also applicable to all the states. And the next is with regard to escrow account. Every builder will have to actually open up an escrow account. 70% of the money has to be deposited in that account, and only with the prior permission of the RERA authority he can release the amount. Whatever money that the purchasers give to the builder at the time of entering into an agreement to sell. Normally, what used to happen was this: builders used to take a lot of money, projects used to be left unattended, and they would disappear in the dead of the dark, or rather in the dark of the night. For example, now you have one particular builder known as TGS, Dreams or something like that. They have not done any construction. They went on with a lot of advertisements, and this is the position with regard to that particular developer, and the case is on. In fact, we have also filed one case in the consumer court. And the next thing with regard to RERA that you need to that is very important is with regard to the this one layout plan or the sanction plan. Initially, what builders used to do is they would say it's a 1-bedroom house or 1.5 or something like that. They will break one wall, then they will make it a 2-bedroom, and they'll say it is a 2-bedroom. We can do this and that. But now it is not possible. They have to get 2/3 majority of the allottees. Allottees means purchases. They have to get prior permission of 2/3 majority, prior 2/3 majority. Only then they can do they can go about any changes in the layout plan. So this is very important. And the next aspect is with regard to this one, as I told you, with regard to if the builder actually falters in doing it, his license can also be suspended. So when his license is suspended, he is given time on priority. Time is given on priority for him to give an explanation as to why his license should not be suspended. So he will be given an opportunity to be heard. Another important aspect of RERA is equal interest penalty. Normally, if you were to observe on most of the sale deeds or the sale agreements, it is to be like this: the purchaser shall pay all the amount on or before such and such a date, failing which the builder will be at liberty to impose a fine of 18% per annum. But now it is a equal penalty can be imposed on both the seller as well as the purchaser. If he says 18% on the purchaser, the same is applicable to the seller also, which means that he has to complete the project within 5 years. Time allotted is 5 years. Now, if the builder is not able to complete the project within 5 years, he is given a maximum extension of 1 year after 5 years under their era. And another important aspect is with regard to the interest rate. With regard to the structural defects. It is the duty of every builder to ensure that the construction, he has to maintain the building for a period of 5 years from the time of construction. And it is very important that he complies with it.